This channel examines the Jeffrey Epstein case using court documents, public records, and verified reporting. We do not speculate. We do not accuse. We document what exists, and what remains unanswered. Everything presented here is drawn from publicly available sources. This is not a theory channel. This is the file. Before Jeffrey Epstein became a headline, a defendant, or a symbol, he was largely invisible. The Department of Justice records, when read carefully, begin not with wealth or influence, but with a man who appeared, on paper, unremarkable. Official documents note that Epstein did not come from a background typically associated with extreme financial success. He was born in Brooklyn in 1953, raised in a middle-class household, and educated through public institutions. There is no record of inherited wealth, family connections to finance, or early signs of elite status. What stands out in the early record is proximity rather than position. By the mid-1970s, Epstein was working as a teacher at the Dalton School, an elite private institution in Manhattan. DOJ summaries and corroborated biographies confirm that he did not hold advanced degrees, yet gained access to a network of affluent families. This environment placed him in daily contact with students whose parents operated at the highest levels of finance, law, and politics. The record does not suggest wrongdoing during this period. What it does show is opportunity. Epstein was present in rooms most people never enter, observing how power spoke, moved, and protected itself. By the late 1970s, Epstein left teaching and entered the financial sector. DOJ referenced timelines indicate that his transition was rapid but poorly documented. Unlike traditional financiers, there are no clear records of licensing, certifications, or early firm employment that explain his sudden ascent. This absence is notable. DOJ documents do not speculate on how Epstein secured his first major financial roles. They simply record that he did. The paper trail begins after the fact, once positions were already obtained. What follows is a pattern that repeats throughout the record. Epstein's rise is visible only after it has already occurred. The mechanisms remain largely undocumented, while the outcomes are undeniable. By the early 1980s, Epstein was managing wealth for individuals whose net worths were measured in the hundreds of millions. Federal filings later describe him as a financial advisor, though the scope and structure of his operations remain unclear. This is where the official record begins to tighten. Not because answers appear, but because the questions start multiplying. The Department of Justice record marks Epstein's entry into high finance not with an application, a license, or a formal resume, but with an outcome. By the early 1980s, he is already positioned inside elite financial circles. How he arrived there is largely absent from the paper trail. DOJ referenced timelines indicate that Epstein became associated with Bear Stearns, one of Wall Street's most powerful investment banks at the time. Official records confirm his presence at the firm but offer limited detail about the terms of his employment, his specific role, or the credentials that justified it. What is documented is speed. Within a relatively short period, Epstein advanced from an undefined entry point to a position that placed him in contact with the firm's most valuable clients. DOJ summaries later describe him as handling complex financial matters for high net worth individuals, language that implies trust without explaining how it was earned. The record does not show Epstein following a conventional path. There is no mention of standardized examinations, regulatory registration, or long-term apprenticeship within the firm. Instead, the documents reflect a pattern seen repeatedly later in his life. Epstein appears already inside the system, operating at a level that typically requires years to reach. Bear Stearns eventually severed ties with Epstein, but DOJ documents are careful in their wording. They do not cite criminal conduct, nor do they detail internal disputes. The separation is noted, not explained. Once again, the outcome is recorded while the cause remains undefined. After leaving Bear Stearns, Epstein did not retreat from finance. According to DOJ filings and corroborated public records, he immediately re-emerged as an independent financial operator. This transition is critical. It marks the moment Epstein moves from institutional oversight into private control. Federal documents describe his new role using vague but powerful terms: money manager, financial advisor, consultant. These labels appear throughout later filings, yet none are paired with a clear business structure. There is no publicly documented hedge fund, no transparent client list, and no regulatory footprint proportional to the wealth he appeared to manage. What the DOJ record shows instead is continuity. Epstein's access did not diminish after leaving Bear Stearns. If anything, it expanded. Clients followed, connections deepened, and scrutiny remained minimal. By the mid-1980s, Epstein's financial identity was established, not through disclosure, but through acceptance by those already at the top. And in the official record, that acceptance is treated as a fact, not a question. As Jeffrey Epstein transitioned into private wealth management, the Department of Justice record begins to rely on unusually imprecise language. Unlike conventional financial enterprises, his operation is never clearly defined. There is no formal hedge fund structure described, no standardized disclosures, and no comprehensive list of clients recorded in federal documents. Instead, DOJ filings refer to Epstein's work through outcomes rather than mechanisms. He is described as managing vast sums for a small number of ultra-wealthy individuals. These clients are characterized as exceptionally powerful, yet the record stops short of naming most of them. Where names do appear, they are often redacted or referenced indirectly, reinforcing the limited scope of what prosecutors could formally document. What becomes clear is scale. DOJ-referenced financial summaries indicate that Epstein controlled accounts containing hundreds of millions of dollars. Some records suggest access to assets far exceeding what would typically be entrusted to an unregistered, opaque financial advisor. Yet the documents do not explain how this trust was established or maintained. The structure of Epstein's business is equally unclear. There are references to shell entities, private trusts, and offshore accounts, but no single organizational chart emerges. DOJ memoranda note that this fragmentation complicated oversight and limited the government's ability to reconstruct financial flows with precision. This ambiguity was not necessarily illegal. Federal filings emphasize that wealth management at this level often operates within legal gray zones, particularly when clients are few and agreements are private. The absence of transparency, while striking, is not framed as criminal by itself. What stands out instead is insulation. Epstein's financial operation appears designed to minimize exposure, not only to regulators but to explanation. Each layer of separation reduced visibility. Each private agreement replaced formal reporting. By the time federal investigators reviewed his finances, much of the structure existed beyond easy reconstruction. DOJ documents acknowledge this challenge directly. Investigators were able to identify accounts and transactions, but struggled to determine the full extent of Epstein's control versus advisory authority. The distinction mattered legally, and the record reflects caution rather than assumption. As Epstein's wealth grew, so did the distance between him and scrutiny. His financial identity was no longer tied to institutions, but to private relationships that rarely leave detailed public records. By the late 1980s, Epstein had achieved something rare: immense financial power without a clearly defined professional footprint. And in the DOJ record, that absence becomes a recurring theme. As Jeffrey Epstein's financial profile expanded, the Department of Justice record begins to reflect a shift that cannot be measured in balances or transactions alone. Wealth, in Epstein's case, translated quickly into access, social, political, and institutional. DOJ-referenced timelines and corroborated public records show Epstein moving seamlessly into elite social environments by the late 1980s and early 1990s. He was no longer merely advising wealthy individuals. He was socializing with them. Invitations, introductions, and affiliations multiplied, often occurring in spaces closed to public view. What the record emphasizes is not fame, but proximity. Epstein appeared alongside influential figures at private gatherings, exclusive residences, and international events. DOJ documents avoid characterizing these relationships beyond what could be substantiated, but they consistently acknowledge his presence within circles of extraordinary influence. This access did not require public recognition. Epstein did not cultivate a media persona or seek public acclaim. According to DOJ summaries, his influence operated quietly, reinforced through personal relationships rather than institutional roles. This approach left minimal documentation, further limiting what investigators could later establish with certainty. The relationship between wealth and social insulation becomes clearer here. DOJ filings suggest that Epstein's financial role often preceded social acceptance. Managing money created dependency. Dependency created trust. Trust reduced scrutiny. Importantly, the record does not assert that access equaled protection. It does, however, show how Epstein's environment increasingly consisted of individuals and institutions accustomed to privacy, discretion, and informal arrangements. Federal documents also note Epstein's growing international footprint during this period. Travel records and property acquisitions placed him in multiple jurisdictions, each with distinct legal and cultural norms. This global presence further diluted oversight and complicated any future attempt to establish a unified narrative of his activities. By the early 1990s, Epstein was no longer an outsider who had entered elite spaces. He was embedded within them. And once embedded, visibility decreased. In the DOJ record, this phase marks a turning point. Epstein's wealth was no longer just a resource. It had become a shield, not absolute, but effective enough to delay questions and defer accountability. In the Department of Justice record, Jeffrey Epstein's properties are not treated as mere real estate holdings. They are documented as functional spaces, environments where financial authority, social access, and privacy converged. By the early to mid-1990s, Epstein controlled multiple high-value residences in key locations, including New York, Florida, New Mexico, and later international sites. DOJ filings reference these properties primarily through transactional records, travel logs, and witness statements, but a broader pattern emerges when those documents are read together. Each property served a purpose beyond status. The Manhattan townhouse placed Epstein at the center of global finance and politics. It was a private space within a public city, allowing access without exposure. DOJ's summaries note frequent visits by prominent individuals, though names are often redacted or described generically, reflecting the limits of what could be formally established. The Florida residence, by contrast, offered distance. Located outside major financial centers, it provided isolation while remaining accessible. DOJ records later emphasize how jurisdictional differences between states would become significant, but at this stage, the property functioned primarily as a retreat, controlled, private, and insulated. In New Mexico, Epstein's ranch represented something different. Federal documents describe it as remote, expansive, and difficult to monitor. Travel records show irregular but purposeful use. The remoteness itself reduced oversight, a factor DOJ investigators would later acknowledge when reconstructing timelines and movements. What unites these locations in the record is control. Epstein owned the spaces. He determined who entered, when, and under what conditions. This eliminated witnesses, minimized documentation, and ensured that interactions occurred on his terms. DOJ filings do not claim that properties themselves facilitated crimes during this period. What they do show is how physical environments reinforced Epstein's broader pattern of opacity. Transactions happened privately. Meetings occurred off the record. Travel between properties blurred timelines and complicated verification. The properties also reinforced Epstein's image. To those who entered these spaces, wealth was undeniable. Power appeared established. Questions felt inappropriate. By the late 1990s, Epstein's residences were no longer just symbols of success. They had become infrastructure, supporting a lifestyle defined by discretion and control. And in the official record, infrastructure matters. Because when investigators later attempted to reconstruct events, these properties shaped what could be seen, proven, and traced. As Jeffrey Epstein's wealth and properties expanded, the Department of Justice record shows another stabilizing force taking shape: legitimacy by association. Epstein did not rely on public credentials or transparent institutions to validate his position. Instead, credibility flowed from proximity. DOJ reference materials note that Epstein frequently appeared alongside individuals whose reputations were already established. Academics, financiers, philanthropists, and political figures crossed his path in documented settings. The records are careful not to overstate these relationships, but they do acknowledge repeated contact within professional and social contexts. This mattered. In elite environments, legitimacy often operates through endorsement rather than verification. Epstein's access to respected institutions and well-known figures functioned as a form of social proof. If he was present, invited, or consulted, it implied vetting, even when no such process was formally documented. Federal filings later reflect how this perception complicated scrutiny. Investigators encountered assumptions rather than evidence. Epstein was treated as someone already accepted, already trusted, already validated. That status reduced the likelihood of questions, complaints, or challenges being raised early. The DOJ record also highlights Epstein's involvement with philanthropic and academic initiatives during this period. Donations, advisory roles, and affiliations are mentioned in transactional terms. What they created, however, was reputational insulation. Association with research institutions and charitable efforts framed Epstein as a benefactor rather than a subject of inquiry. Importantly, DOJ documents do not claim these associations were improper or fraudulent in themselves. The issue is structural. Legitimacy derived from association does not leave a clear paper trail. It cannot be audited the way licenses or registrations can. As a result, when federal authorities later attempted to map Epstein's influence, they encountered networks built on perception rather than documentation. Invitations replaced contracts. Introductions replaced oversight. By the late 1990s, Epstein's standing no longer depended on explaining how he made his money. His environment assumed that explanation had already occurred. And once legitimacy is assumed, it rarely demands proof. By the late 1990s, the Department of Justice record begins to reflect a critical intersection. Epstein's assumed legitimacy meeting regulatory silence. This phase is defined less by action than by absence, specifically, the absence of sustained oversight. DOJ-referenced reviews note that Epstein's financial activities existed in spaces where regulation was fragmented or optional. Private wealth management for a limited number of clients did not trigger the same reporting requirements as public funds. Offshore structures, private trusts, and bespoke agreements further reduced visibility. Each choice, taken individually, was common. Together, they created a system that operated between the lines. Federal documents emphasize that no single agency maintained continuous authority over Epstein's financial world. Banking regulators saw pieces. Tax authorities saw fragments. Corporate registries reflected entities without revealing control. The record shows no unified supervisory framework capable of capturing the whole. This regulatory diffusion mattered. Oversight relies on thresholds, size, frequency, disclosure. Epstein's operation appears designed to remain just below or outside those triggers. DOJ memoranda later described the difficulty of determining when advisory activity crossed into control, and when private arrangements demanded public reporting. The record also reflects a cultural factor. Epstein's clients were sophisticated, legally represented, and accustomed to privacy. Their participation reduced the likelihood of complaints. Without complainants, regulators had little reason to look deeper. Silence became self-reinforcing. Importantly, DOJ filings avoid labeling this structure as illegal. They frame it as permissive. The law allowed such arrangements to exist, and so they did. Where ambiguity appeared, it favored discretion over disclosure. As Epstein's financial and social ecosystem stabilized, scrutiny remained episodic and reactive rather than continuous. Reviews occurred only after specific triggers, a transaction flagged here, a question raised there. None assembled the full picture in real time. By the early 2000s, Epstein's position was entrenched. His wealth was accepted. His access normalized. His regulatory footprint remained light. In the official record, this is not portrayed as failure by a single institution. It is shown as the outcome of a system built to see parts, not patterns. In the Department of Justice record, the early 2000s mark a subtle but important shift. Epstein's structure, financial, social, and regulatory, remained largely intact, but small inconsistencies began to surface. Not alarms, not accusations, just points of friction that, in retrospect, signaled strain. DOJ referenced materials indicate that questions first emerged at the margins. They were not directed at Epstein's wealth itself, but at behavior that fell outside the expectations of his established legitimacy. These early concerns did not immediately trigger federal action. Instead, they entered the system unevenly, handled by local authorities and civil processes rather than national enforcement. What the record shows is fragmentation. Information existed, but it was not centralized. Complaints were isolated. Jurisdiction was limited. Each inquiry examined a narrow slice of conduct without access to the broader context of Epstein's finances or associations. As a result, early scrutiny lacked momentum. DOJ summaries later note that Epstein's prior insulation still held during this phase. His resources allowed for legal representation, negotiation, and delay. His social standing discouraged escalation. His regulatory footprint offered few obvious entry points for comprehensive review. At the same time, the record reflects growing complexity. As Epstein's activities expanded across locations and years, reconstructing timelines became more difficult. Witness recollections varied. Documentation was incomplete. Jurisdictional boundaries restricted information sharing. Federal authorities did not yet appear as a unified presence. DOJ documents make clear that early stages were characterized by observation rather than intervention. Information was noted, not acted upon. Patterns were not yet formally identified as such. Importantly, the record avoids framing this period as neglect. Instead, it emphasizes constraints. Legal thresholds had not been met. Evidence remained localized. Authority was limited by geography and scope. But strain, once present, tends to accumulate. By the mid-2000s, Epstein's system still functioned, but its margins were thinner. The very features that once protected him, privacy, fragmentation, discretion, began to generate inconsistencies that could no longer be fully contained. In the DOJ record, this is the moment before consequence. Not collapse, but exposure. According to the Department of Justice record, the transition from strain to formal legal action did not occur suddenly. It was the result of convergence, multiple pressures aligning across time, jurisdiction, and evidentiary thresholds. By the mid-2000s, information that had previously existed in isolation began to intersect. DOJ summaries indicate that allegations, witness accounts, and corroborating details increasingly overlapped. What had once appeared as separate incidents now suggested a pattern that could be evaluated collectively, rather than individually. Jurisdiction became decisive. Federal documents show that once conduct crossed state lines and involved interstate elements, the scope of potential enforcement widened. This shift allowed federal authorities to review material that had previously remained outside their reach. The record emphasizes that timing mattered, not because information was new, but because authority had changed. The DOJ filings also reflect a recalibration of posture. Observation gave way to preparation. Legal teams assessed what could be charged, what could be proven, and what would withstand scrutiny in court. This phase is marked by caution rather than urgency. Each step was documented, reviewed, and constrained by procedural standards. Epstein's earlier insulation still influenced outcomes. DOJ records acknowledge extensive negotiation between defense counsel and prosecutors. The resources available to Epstein shaped the pace and structure of proceedings. Legal strategy, rather than factual discovery alone, became a defining factor. What emerges in the record is not inevitability, but selectivity. Charges were narrowed. Timelines were limited. Conduct was framed within specific statutory boundaries. Federal authorities focused on what could be sustained, not on constructing a comprehensive account of Epstein's rise or behavior. This narrowing would later define public perception. Many questions remained outside the scope of prosecution, not because they were dismissed, but because they exceeded what the legal process could contain. By the time formal action materialized, the case no longer reflected the full arc of Epstein's ascent. It represented a moment, chosen carefully, constrained deliberately, and documented precisely. In the DOJ record, this is where the rise begins to fracture. Not because everything is revealed, but because the system finally acts. In the Department of Justice record, Jeffrey Epstein's rise does not end with a dramatic reversal or a definitive explanation. It ends procedurally. The arc that began with undocumented opportunity concludes not with clarity, but with limitation. Federal filings show that once formal charges entered the system, the narrative narrowed rapidly. The DOJ record focuses on specific offenses, defined timeframes, and legally sustainable claims. Everything outside those parameters, the origins of Epstein's wealth, the full extent of his network, the informal systems that enabled his ascent, falls away from the prosecutorial account. This is not an omission by accident. It is design. The justice system documents what it can test in court. Epstein's rise, built on private relationships, opaque structures, and assumed legitimacy, resists that kind of testing. As a result, the official record addresses the end of his legal exposure, not the full story of how he arrived there. After Epstein's death, the record contracts further. DOJ reviews pivot to institutional process, custodial decisions, procedural failures, administrative accountability. The question of rise becomes secondary, then irrelevant. No trial occurs. No evidentiary record is fully examined under cross-examination. The ascent remains largely untouched by judicial resolution. What the DOJ record ultimately preserves is a boundary. It shows where authority reached and where it stopped. It explains what could be charged and why. It does not reconstruct a life in totality, nor does it attempt to assign broader responsibility beyond what the law allows. In this sense, Epstein's rise ends the same way it began, partially visible, formally acknowledged, but never fully explained. The billionaire status is documented. The access is recorded. The consequences are procedural. What connects the beginning and the end is not secrecy alone, but structure. A system capable of documenting outcomes, yet ill-equipped to narrate how informal power accumulates. This is the conclusion of the rise as reflected in the official record. Not a revelation. Not a confession. But a file closed according to rules. The documents exist. The questions remain. This channel will continue examining what is public, and what is still hidden. If you value documented analysis over speculation, consider subscribing. More files coming.